Ready? Exercise number 7, Series B, Legal Matter, start. In order to address the issue of corrupt practices in securing contracts or arbitral awards, a need was felt to ensure that all the stakeholder parties get an opportunity to seek unconditional stay of enforcement of arbitral awards where the underlying arbitration agreement or contract or making of the arbitral award is induced by fraud or corruption. Also, to promote India as a hub of international commercial arbitration by attracting eminent arbitrators to the country. It was also felt necessary to omit the eighth schedule of the Act. In the light of above circumstances, it has become necessary further to amend the Arbitration and Conciliation Act 1996. Stop, next para. In the present regime, a party may file an application before the court under Section 34 of the 1996 Act for setting aside of an arbitral award. However, after the 2015 amendment to Section 36 of the Act, an automatic stay would not be granted on operation of the award by mere filing an application for setting it aside. The bill clarifies that a stay on the arbitral award may be granted by the court even during the pendency of the setting aside application, if it is prima facie satisfied that the relevant arbitration agreement or contract making of the award was induced by fraud or corruption. This shall be deemed effective from October 23, 2015. Stop, next para. Schedule 8 to the Principal Act specifies certain qualifications, experience and accreditation norms for arbitrators. These requirements include that an arbitrator must be first an advocate under the Advocates Act 1961 with 10 years of experience, or second, an officer of the Indian Legal Service, among others. The bill seeks to omit Schedule 8 and states that qualifications, experience and norms for accreditation of arbitrators shall be specified by regulations. Responding to the debate, the Law Minister Ravi Shankar Prasad informed the House that the proposed amendment to Section 36 of the Act, despite use of words fraud/corruption in Section 34, was necessary as the latter does not provide for an automatic stay of the award. He stated that this is in furtherance of Section 34, which states that an award which is in conflict with public policy may be set aside. With respect to omission of Schedule 8 of the Act, the Minister said that there will be greater flexibility in the Arbitration Council of India and it will help in promoting institutional arbitration by inviting arbitrators from abroad, thus furthering the goal of making India a hub of international commercial arbitration. During discussion on the bill in Lok Sabha, many members had appreciated the government for proposing to omit the eighth schedule as it will attract eminent international arbitrators. Stop, next para. BJD MP Amar Patnaik supported the bill. He also raised a technical query with respect to the amendment. He highlighted that on one hand, the proviso to section 34 subsection 2a provides that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. However, he asked that how is it possible to establish a prima facie case that the award was induced by fraud without reapplication of evidence, given that any issue of fraud is a mixed fact of law and fact and cannot be decided summarily merely on the basis of evidence recorded in the initial arbitral award. Stop. Thank you very much.